All right, if you're a 1L, you've been hearing this phrase over and over in torts, the reasonable person. Today, we're going to break down exactly what that means. We'll get into what it is, why it's so important, and of course, what you absolutely have to know for your final exam. So let's just start with a really basic question that cuts right to the chase. Let's say you get into a minor car accident. Your defense is, hey, I was really doing my best. I'm just, not the most coordinated driver. Does the law actually care about your personal best effort? Well, as we're about to find out, the answer is a hard no. And that no is the key to understanding this entire concept. So here's how we're going to tackle this. First, a quick refresher on negligence. Then we'll get into the objective standard of care and finally meet this so-called reasonable person. From there, we'll see how the standard gets tweaked for things like emergencies or for children, and we'll wrap it all up with the black letter law, the stuff you need for your outline. Okay, let's get into it. To really get a handle on the reasonable person, you first have to know where this idea even fits into the legal landscape. And its home, its natural habitat, is smack in the middle of a negligence claim.
Right, so for any plaintiff to win a negligence case, they've got to prove all four of these things: duty, breach, causation, and damages. The defendant had a duty, they breached it, that breach caused an injury, and that injury resulted in damages. Simple enough. But our whole conversation today, everything about the reasonable person is packed into that second element, breach of duty.
And that leads us to the big question: how does a court decide if someone's actions were a breach? What's the ruler they use to measure someone's conduct to see if it comes up short? The law's ruler is something called the standard of care. You can just think of it as a baseline for responsible behavior. It's the minimum level of attention and caution society expects from you. If your actions dip below that line, well, that's a breach of duty. Now this is really the whole ballgame right here. The law had a major choice to make. It could have gone with a subjective standard where it would ask, okay, considering this defendant's clumsiness or their inexperience, what was reasonable for them? But it didn't. It went the other way, choosing an objective standard that asks a single uniform question: how would a reasonably prudent person have acted in this situation? So that brings us face to face with this ghost, this legend of the law. Who on earth is this reasonably prudent person that the entire negligence system seems to revolve around? Justice Oliver Wendell Holmes just nailed the why behind it all. He basically said, look, for us all to live together without constant chaos, we have to agree on a baseline for behavior. We have to give up our individual peculiarities, as he put it, for the good of the group. Your personal best just might not be good enough to keep the people around you safe. It's so important to remember this person isn't real. They're a complete legal fiction, an invention. They are not the average person on the street, and they're definitely not the person sitting in the jury box. The reasonable person is this idealized figure who is careful, prudent, and knows what any normal adult in the community would know, like, that you shouldn't text and drive or that ice is slippery. They're the benchmark the jury uses to measure the defendant's real-world actions. Now, I know what you might be thinking. This sounds kind of harsh, and you're right, it can be. But the law isn't a total machine. It does recognize that certain situations can change the analysis and modify that standard of care. First up, let's talk about emergencies. What happens when you have to make a split-second decision when everything's going crazy? That's what the emergency doctrine is all about. So if a defendant is hit with a sudden, unexpected crisis that they didn't cause, like a deer jumping out in front of their car, the law cuts them a little slack. It doesn't judge them against someone who had all the time in the world to think. Instead, the jury has to ask, what would a reasonable person have done in that same emergency? The context matters. Okay, star this in your notes because this is a huge deal for any torts exam. The law draws a very bright line between physical and mental conditions. It adjusts the standard for physical disabilities. For instance, a blind person is held to the standard of a reasonably prudent blind person. But, and this is the controversial part, the law traditionally refuses to do the same for mental conditions. A defendant with a mental illness is generally held to the same standard as someone without one. The courts worry it would be too easy to fake and too hard to prove, and they figure that if someone has to bear the loss, it should be the person whose condition caused the harm, not the innocent victim. So we've seen how the standard can be adjusted down a bit for emergencies or physical traits. But this isn't a one-way street. The standard can also be ratcheted up. This is pretty intuitive. If you have special skills or knowledge, the law says you have to use them. A doctor isn't judged against the standard of a regular person on the street. They're judged against the standard of a reasonable doctor. An airline pilot, a lawyer, an expert electrician, they're all held to a higher standard. The reasonable person becomes the reasonable professional.
All right, let's get to our last big exception to the rule, and it's a huge one. It involves a group that the law almost always treats differently: children. For kids, the law basically tosses the objective standard out the window. It swaps it for a much more subjective test. A child's actions are compared to those of a reasonable child of the same age, intelligence, and experience. This is a huge shift because it means the jury can actually consider that specific kid's maturity and capabilities.
But, and you knew there was a but coming, this is law school after all, this special protection for kids isn't absolute. There is a very, very important exception. When a child does something the law considers an adult activity, things that are inherently dangerous and that adults usually do, like driving a car, a speedboat, or a snowmobile, that special kid-friendly standard is gone. The child is held to the exact same objective, adult standard of care as everyone else. The thinking is pretty simple. If you're going to engage in adult activities that put the public at risk, you've got to follow the adult rules.
Okay, that was a lot. So let's boil it all down. This is your cheat sheet, the black-letter law you want to have locked down for your final.
Let's recap. The default standard is objective, the reasonably prudent person, and your personal flaws don't matter. But that standard is adjusted for physical characteristics. In sharp contrast, mental conditions are traditionally not taken into account. Remember that distinction. Then the rule flips for children, who get a subjective standard based on their age and experience, unless they're doing something dangerous, like driving a car. And finally, a sudden emergency you didn't create can also modify the standard. That's the framework right there. And we'll end on this. That rule about not considering a defendant's mental condition, it is easily one of the most criticized rules in tort law. Critics argue it's outdated and doesn't reflect our modern understanding of mental health. As science evolves, it raises a tough question. Should the law evolve with it? It's a debate that's still very much alive in courtrooms and classrooms today, and it just goes to show you that even the most bedrock legal rules are never truly set in stone.